All right, guys, so let's talk about the video. The film is pretty much a documentary that I posted for you on Moodle. It was called One More River, the deal that split the Cree. So anybody have any comments about the video they want to share with the class? Larissa?
I just watching the video, there was one part where a gentleman went up to talk, and he said, "Do you want to? How can you put a price on our soul? Like the land is their soul." And you just see through the whole video how everything's being taken from them with an excuse for money and how it's impacting them so severely. It just gave like a really depressing outlook that a lot of people aren't aware of.
Yeah, no, I totally agree. It was a very powerful film, and it certainly was powerful from the aspect of those who actually were against the deal that the Grand Chief was promoting. Michelle?
I was really surprised that these people all agreed to go along with this, especially considering the affairs of the environment with global warming and all of the bigger countries, saying, no, we're not going to do this. We're going to use better means of energy, such as green energy, solar power, windmill farms, and things like that. Personally, I think that we should just go back to the Mennonite ways and live off the land. And when it gets dark, you go to bed. When it's light, you get up and you go and you grow your own food. And because the way we're doing things now isn't working, obviously, and we're killing our planet. And every video you make us watch, I cry. Like, wow. It was very,
Well, it's
very
working.
moving
That's
and
good.
touching.
That's good. It's working. Yeah, thanks, Michelle. No, I mean, I get it what you're saying. It's certainly what you're saying is an extrapolation to a great degree of a lot of Indigenous culture. But remember, and this is important to remember, that this film, clearly the focus of the producer for this film was on those who objected to this project. The damming up of another river, subsequent about 15, 20 years subsequent to the James Bay deal, right? But remember that while the focus of the film was from the position of those who opposed it, and that's pretty much where the center was for the film. Remember that at the end of the day, the vast majority of those in the relative First Nations voted, in fact, in favor of it, and the reason they voted in favor was clearly one thing and one thing only, and that's money. Where we're talking about the province of Quebec throwing $70 million at the Cree for the next 50 years, $7.5 billion, and that's something that is really, really hard to turn away from. So we have some more hands. So where'd they go now? Carolina?
Well, I think I also thought, just like Michelle did, and I think everyone else would, that the video had a huge impact. It was very saddening to know that people face this kind of choices. But I was actually surprised. Till now, I never really considered that there could be inner conflict between the Indigenous people themselves when it comes to that. So I was really surprised, and it just let me think about it in a different way, I guess, just acknowledging that actually there are Indigenous people or leaders who might be affected by the mainstream culture, and they will be going for profit rather than the cultural importance of the land as the spiritual part of their culture. They just rather have the money. So I just thought it was interesting to see that aspect of it, that within itself there are problems rather than just from the white people.
Yeah, absolutely, and that's a good point. And I've said this before. As Europeans, a lot of us are European descendants. A lot of us see Indigenous peoples as a homogenous group, as they're all the same. They all have the same fundamental attachment to the Creator and the earth and the land, and the water. And they must all feel the same way. Well, they don't. It's like there's different cultures and different environments within themselves, and even within First Nations. And this is not an uncommon thing, where and again, we've talked about this, where the Indian Act put into place the band structure for First Nations. That isn't a tribal structure they had before, but it was something that they were forced to create and govern themselves by, or govern themselves, subject to the whims of the Indian agent. But even there still is, in a lot of cases, and I hear that I've taught this course now for 8 years. there are lots of times when members of a band, when they have meetings that come together, have disagreements with what the chief, who's duly elected for the band, has to say, or what the band council has to say, right? So it's you do find disparities between internal members of the First Nations and the bands. Rainbow.
So, I guess one of like my big takeaways from this video was, I mean, like of course, like monetary compensation and economic development do help Indigenous communities, and I mean, just like anyone really. But I feel like this documentary did do a good job of like highlighting the debate within communities about like direct compensation or the problems of direct compensation. And like I tend to like make this argument a lot actually that giving people money isn't going to solve a lot of the problems that Indigenous peoples face, although that is like one of the like most common forms of like reparations that are used, or like compensation that is used for Indigenous communities. So, and not only that, but is there like, I feel like, wait, sorry, I'm getting confused by my own thoughts, but like some, I guess like drugs and alcohol is like one of the main things I think about how money can be used uh, in like non-beneficial ways for Indigenous communities. But not only that, but there's also a lot of corruption that happens in Indigenous communities, and where chiefs uh, and their council will sort of like hoard money. So I don't know. There's just like uh, both. I can see both like good and bad that when it comes to like monetary compensation to that extent. So I guess that's all I wanted to say.
Yeah, no, those are really good points. And probably most of you don't know this, but I can tell you that, for instance, and it's really interesting to see how the band council decides when to deal with money when it actually has money. This is huge money, right, for the James Bay Cree. But even for instance, for those of you who know anything about casinos in Ontario, a casino was built in the township of Ramera, which is just to the northeast of Aurelia on Lake Couchiching. And was built about 30 years ago. And it started off as a relatively small kind of operation, but it's grown into a very large venue. Lots of tables, lots of slot machines, and a 400 to 500 room hotel that goes with it. And they also have entertainment, and stars that, well, maybe not you guys would know, but I certainly know, would appear there, and it would be a very attractive place to go. And because there are no casinos in the city of Toronto, right? So if they have buses, that they take 3, 4, I don't know how many. I could make a number up because it is a number. I don't know, but there's a constant stream of buses that not the last year, obviously, but pre-COVID, that would go up to Rama. The casino was called Rama, right on the Ramera Reserve. Would go up and you take people there, and go up there and come back, at night, like as in you'd sleep on the bus, after midnight kind of thing, but you'd gamble from 3 o'clock in the afternoon to 11 o'clock at night, whatever it is. Anyway, it's a huge, huge moneymaker for both the province of Ontario, that's the provincial jurisdiction as opposed to federal, that has jurisdiction over gambling. All right, so OLG, Ontario Lottery Corporation, basically. But anyway, having said that, what the band does for its youth, in that particular First Nation, is that every young person who becomes 18 years of age, who's a member and enrolled on the band council roll for that particular First Nation, gets $100,000 as a gift when they turn 18. Every 18-year-old belonging to that First Nation. That's one of the ways that band sees, its way to distribute wealth. And I can tell you because I practice law in that area, so I was pretty familiar with it. Is that there would be a lot of hot, fast cars, driving around Aurelia that you knew where they came from, because these young people were spending their money doing exactly that, together with however else they did it. So having said that, I'm not saying that that was just a common thing to do. I'm not saying that there weren't young people who were very smart and their parents sat down with them and they talked about how they should invest the funds, hopefully paid for education as part of that kind of thing. But that's one of the ways that in fact a relatively wealthy First Nation distributed its capital. Farhang, you got to put your hand up.
Just one small part about the documentary I found interesting was when Deputy Grand Chief Matthew Makash said that the greatest tool of the colonizer is the mind of the colonized. And I found this important since if people are divided amongst each other, they're not able to like coalesce and like focus their attention towards one issue and actually get things done. Instead, they may argue amongst each other and be split. So I just found that interesting.
Yeah, and yeah, so it's really interesting. And what's really interesting too is as a function of everybody coming together for this. And this is what tonight's class is on. Tonight's class is on, for the most part, modern treaties and how they're negotiated. And that's what, I mean, a great deal of Quebec, as British Columbia, didn't have any of the large number of treaties, after the Robinson-Huron Superior Treaties went in play. So the very first modern treaty called a Comprehensive Land Claim Agreement was in Quebec. It was with the Cree and the Inuit. Inuit, as you guys know, are Indigenous peoples in the Arctic Circle, entering into an agreement with the Quebec government for the St. James or James Bay Cree North Quebec Agreement. Basically, that's not quite the wording of it, but that's what it was. We're going to talk about that a little bit tonight. But it was the very first modern treaty, right? And they as I said this at the beginning of the film, Quebec went in there to build that hydroelectric dam, on Indigenous territory, initially without permission. And it was a function of a lot of political will and protests that eventually brought Quebec to the table to sign the James Bay Cree Treaty Agreement. And now this, which is this Comprehensive Claim Agreement, which is the subject of the film you just watched, is another negotiation of a modern treaty, right? So that's what we're going to be talking about tonight. Does anybody else have any other questions or anything about the video? No? All right, guys, then thank you very much. We will now move to the lecture. So let's deal firstly with this, which is essentially land resources and fundamentally how Indigenous rights, Aboriginal treaty rights, and Aboriginal rights that aren't treaty related are in fact extinguished. All right, so that's important to know. And then the second part of the lecture will be more specifically on the negotiation of modern treaties. All right, first things first, here's a video I've posted on I've embedded into the PowerPoint for you. We're not gonna watch this because I don't wanna take up the time to watch this. It's about 25 minutes long. This is Professor Wicken, and he is a professor emeritus of history at York University in Toronto. And remember, I've told you this on a number of occasions, whenever an Indigenous people have to assert their rights to basically push back against somebody who is infringing upon their territory, hunting, trapping, or doing things like timber cutting or mining, any of those things, or an Indigenous person is charged with an offense in that, for instance, just like Donald Marshall we talked about last week, basically collected all those eels, fished all those eels in Nova Scotia and was charged with commercial fishing and fishing out of season kind of thing. Every time an Indigenous defendant or a plaintiff who is looking to establish or protect their rights that are traditionally Indigenous, they have to bring in historical evidence. We talked about this when we looked at it, very early Supreme Court Canada decisions, because the court has basically said this, the Supreme Court, is that if you are going to assert a right to stop somebody else from infringing on your territory or to provide a defense against a charge against you, you are going to have to prove to the court what your particular, what became your First Nation, but originally your tribe, did at the time of European contact. All right, and to do that, you have to bring in historians to provide that context. And again, history is not objective, it's very much subjective. So the indigenous parties would bring in their historians to give, that view of what they believe the historical context was at the time of contact. And again, the other party, which is usually either the federal or provincial government, they would bring in their historian to do that. And this guy, this picture you see, this guy Wiccan, he was the historian in the Harry Daniels case that we talked an entire class about, which established that Métis and non-status Indians are constitutional Indians under Section 9124 of the Constitution. This is the guy that provided the evidence for Daniels. He has done it a ton of times. He is the go-to historian on Indigenous matters. He actually provided a historical context in the Donald Marshall case as well, right? So he is an incredibly respected historian. In the Daniels decision in the federal court, the trial division, the trial court judge said very clearly that he preferred the testimony of this guy, Wiccan, over the testimony of the historian provided by the federal government, basically who was giving evidence contrary to what Wiccan was. So anyway, this is a really decent little talk that I've given for you. It's an interview. He, one of the, I think was one of the deans at York, interviews Wiccan at an audience at York University on the job of providing historical evidence. So that's kind of interesting. So that's there for you to watch, if you find the time to do it on your own time. Okay, so let's talk about the protection of Aboriginal rights. So this carries on from last day, all right? So in order for a right to be protected under Section 35, that's the Regina and Sparrow test we mentioned last day. Two things must be there, part of the test, that the right must not have been extinguished prior to 1982. Why is 1982 the important date here? Anybody? What happened in 1982 that's really, really relevant for this issue? I can't see whose hands up. Oh, Carolina?
Well, weren't the rights constitutionalized?
Exactly, thank you. Yeah, sure. The Canadian Constitution was patriated in 1982. The British North America Act of 1867 became the Constitution Act of 1867, and the Constitution Act of 1982 and the Canada Act created the country. Section 35 is part of the Constitution Act, and we've seen Section 35 a number of times, but that's right, 1982, and we saw this last week when we looked at the wording of Section 35. It basically said that the existing rights as of 1982, Aboriginal rights, were constitutionalized, which is an incredibly important concept, right? It's not just that they were put into a statute to be protected, but they became part of the Constitution, which means they can't be changed without a constitutional amendment, which is an entirely, incredibly complex and difficult process to undertake. So if something is constitutionalized, it's like it's written in stone to a great degree. All right, so what we have here is that in order for a Aboriginal right to be constitutionalized under Section 35, it cannot have been extinguished prior to 82, right, when the Constitution was put into place, and the state cannot justify an infringement of that right if it has tried to extinguish it. Okay, and we'll talk about that. All right, so extinguishment. Extinguishment basically is that there is a recognized Aboriginal right. So for instance, an Aboriginal right when the Robinson-Huron Treaty was put into place in 1850. So the reserve for Garden River and Batchewana were created. Those two reserves were created, but there is thousands and thousands of acres or hectares going north and west from Sault Ste. Marie and east that is part of that original treaty territory. Okay, so those two First Nations maintained the rights, and now as a function, of the Pauli test in the Supreme Court of Canada of 1990, Métis as well. So Métis and First Nations have the right to fish, hunt, and trap in the treaty territory that became Crown land as a function of the Robinson-Huron and Robinson Superior Treaties, right? So they have that right. Indigenous peoples have those rights, but the state being the government, either provincial or federal government, has the right. It is a right. It is well, and it's embedded in constitutional law. They have the right to extinguish some of those hunting, trapping, or fishing rights if they meet the tests that the court has set out. All right. So the Calder decision, 1973, established that in order for a right to be extinguished, as in to limit the hunting and trapping and fishing, that there must be legislation. So there has to be a statute enacted either by the provincial government, which is sitting in Toronto, or the federal government sitting in Ottawa. There has to be a statute put in place that extinguishes a Aboriginal right in what's considered to be a clear and plain manner. And so those are pretty straightforward terms, basically. And Vanderpeet in the Supreme Court in 1996 expanded upon this to basically say that Parliament has to have recognized the existence of the right and deliberately chose to extinguish it. Right? They can't do it by way of just putting it into a statute, which is what Calder said. In say they passed a budget bill, and governments do this all the time now. They pass budget bills that are hundreds, if not thousands of pages long, and they often put small little sections in the budget bill that had nothing to do with the budget whatsoever, but deals with other things that could possibly, for instance, extinguish an Aboriginal right. They could just have one section, section 946 of the 2021 budget bill extinguishes the right of Aboriginal people to hunt and fish in the treaty territory of the Robinson-Huron Treaty. They could do that, right? But it's no longer constitutional to do that because it's just not plain and clear, right? And it doesn't clearly identify that that's what they're doing. You just can't take this kind of a thing and slip it into another piece of very broad, wide-ranging legislation. You have to be very specific to do it. This is what we're doing with this statute. We're deliberately acknowledging this right, and we're deliberately going to extinguish it. Okay, right? Only province or only the federal government has the power to extinguish it. Provinces can't do it, although provinces often ask the federal government to do it for them. All right. But having said that, extinguishment of a right now that is now constitutionalized because it existed in 1982 and is now constitutionalized under Section 35, and Carolina was quite correct in this, is almost now impossible to do. Right? So if it's been constitutionalized, as in recognized in 1982 and not fallen apart as a function of the Sparrow test, then it almost can't be done, right? Several federal statutes contain clauses, that say this, and most of them do now. At the very beginning of the statute, it's almost as part of the preamble of the statute. It basically says this, that no matter what is said in this statute, nothing in here is intended to abrogate or derogate from existing Aboriginal treaty rights. Right? So it's a re-emphasis on the fact that it has to be clear and plainly done. Right? So in Sparrow 1990, when there is a prima facie infringement, what's prima facie mean? Anybody? It's a Latin term, but a lot of you guys have been in jury for 3 or 4 years. Prima facie, what does that mean? Elizabeth?
Like at first glance or like at first sight?
Excellent, exactly what it means, right? Okay, so at first sight, where there is an infringement of an Aboriginal right, then the Indigenous peoples whose right is being infringed must prove it. Okay, and now we're talking about, okay, here's the right. If it's been infringed, we have to prove that it's our right, which means here comes all that historical evidence as to what our rights were at the time of contact. Okay, so it's no easy task, right? The reality is that any significant restriction on Aboriginal right is at first glance, Elizabeth's terminology was perfect, is at first glance an infringement, all right? However, the Supreme Court, these are cases now that I've drawn from various decisions. The Supreme Court has held that there has been no infringement of Aboriginal rights where there's an obligation imposed to hold a license to fish or hunt, right? Or there's an obligation to declare one's catches, right? Or laws relative to the safety of firearms. All right. So in these cases, if it's the province and the federal government's given authority for this, if the federal government or the provincial government puts in place under the Ministry of Natural Resources, puts in place things like you have to have a license to fish or hunt, or you have to declare your catches, or we have laws for the safety of firearms that could be federal, more than provincial actually. If any of those things happen, the Supreme Court has basically said that's not an infringement of rights. So even though Indigenous peoples have the right to hunt, fish, and trap north of Sault Ste. Marie. They still have to get a license in that regard. They still have to declare their catches. Okay, so you kind of understand that. So that's not considered to be an infringement of their rights. That seemed to be a reasonable expectation. However, the Supreme Court has held that there has been infringement with respect to this, where there's restrictions on the quantity of the catch. Okay, so if you're Indigenous, you have to get a license if you're going to hunt or trap or fish, but you're not restricted to the quantity where non-Indigenous people would be. Okay, so it's an infringement to limit your catch. Basically, it's a limit to specify that you can only catch certain species in the season for hunting or fishing, right? And so that's an infringement, and governments cannot impose a fee for the granting of a license. All right, so everybody kind of understand this. Let's think this through, because it's important, because it gives you a really good context. So if you're Indigenous and you want to go fishing on a lake north of Sault Ste. Marie that has a season for being open and a season for being closed, and the lake next door may well have a different season. All right, so the court has basically said, the Supreme Court has said, you have to get a fishing license to fish. All right, so that's seen as a requirement. So that's not an infringement upon your Aboriginal rights. So you can fish, all right? However, the Ministry of Natural Resources has regulations in place saying you can't catch more than 6 pike or whitefish or whatever at a time, right? That's a limit. So you have to get a license to fish, but even though there is a restriction on the number of fish you can catch, same thing applies to moose in season, right? So it also applies to big game. But you have you have to get a license, but you don't have to worry about how many fish you catch. Whereas if you're non-Indigenous, you have to live within the restrictions that the MNR puts in place. Okay, and if the lake you're fishing in says that you can only fish pike at this time of year, and you can only fish trout at another time of year, kind of thing, right? And that certainly applies if you're non-Indigenous. But if you're Indigenous, you don't have to worry about that. You can fish any species any time of year you want. All right. And when you apply for that license, you don't have to pay a fee for it. You get it just upon application. Whereas if you're non-Indigenous, you have to pay a fee. All right. So everybody kind of get that. It's a really good example, I think, of how things are different if you're, basically exercising what are considered to be traditional Aboriginal, Indigenous, and inherent rights. Okay. So now let's go past that. So once an infringement has been proven, so it goes beyond those examples just gave you, something else has happened. So for instance, somebody in north of Goulet somewhere has cut timber down. All right, and cutting timber is an Indigenous right to a great degree to build huts and camps and what have you. But somebody else has come on to treaty lands and done that, and they're non-Indigenous. So all of a sudden, if you are, again, a member of Garden River, Bechuana, or your Métis for that matter, you're going to be really pissed that somebody's cut timber on these lands, right, without getting your approval, essentially. So you complain about it, which usually means you sue, whoever did it. You bring a court application for it. And if that's the case, then if that timber has been cut, the state, i.e. the federal government, has to basically show that it was justified. Okay, so we're not talking now, for the most part, because nobody would start a lawsuit over something like, a couple of guys going into the bush and cutting down timber to bring it back to their house to stoke their fire. That's not what happens. What usually happens is that large timber companies are granted a license by, some level of government to come in and cut great swaths of timber, 600 clicks north of here, right? So it's out of sight for the most part, and there's all kinds of examples across the country where that's happened. Believe it or not, it happens without anybody asking for permission. Not so much in the last 10 or 20 years, but certainly up to this point in time, and still occasionally now. So here's what's happened. So somebody who lives in the area, on the treaty lands, they don't live in a rural area like the Sioux. recognize this has happened. They bring it to the attention of the First Nation. First Nation, looks into it, and they sue, whoever the timber company is and the government that gave them the license for it, saying, hey, that's a prima facie infringement of our Aboriginal rights, right? And then what happens is the defendants, fundamentally the timber company, but through the federal government, has to prove that they had the justification to do that. All right. And here's what the test is for justifying an infringement, right? First, is the state pursuing a valid purpose? All right. So what that means is, did the government grant a license to that timber company to cut those woods for a valid purpose, right? And secondly, does the infringement, right, because we recognize that that is an infringement of Aboriginal rights, did it respect the honor of the Crown and the fiduciary relationship owed by the Crown? And those are two tests that have been put in place with Supreme Court of Canada decisions dealing with resource extraction. All right. So dealing with the purpose. Is the purpose important enough to justify restricting an Aboriginal right? That's a decision the judge has to make. All right. So the government, who now has the burden to justify the infringement, has to prove to the judge that granting the license to cut the timber, had a broader importance to the country or the population in the area or the economy of the province itself. It was more important for the timber to be cut to provide for those kind of benefits than it was to simply respect the Aboriginal rights over that timber. The state must identify a specific objective, all right? And again, the state is almost always arguing the position, usually of a private company that's been granted a license to conduct the activity authorized by the state being the Crown, right? So these are the kinds of things that over the course of time, courts have agreed have been justification for an infringement of an Aboriginal right. So whatever was done was for the purposes of conservation of fish and wildlife. So we're not talking here about cutting down trees or mining. Or safety was a reason. So perhaps something was dammed, a river was dammed to keep it from potentially breaching, lands where life was at risk, right? Or this is where usually the big infringements come into play, that the justification was there for the purposes of the development of agriculture, forestry, mining, hydroelectric power, or the building of infrastructure, right? So the court, including the Supreme Court of Canada, has basically said, if these are the reasons for the infringement, then the purpose of the infringement is sometimes so beneficial to so many more people than just, those indigenous peoples who exercise their treaty or Aboriginal rights, that the infringement is justified, okay? As to fiduciary duty, because again, the infringement has to be seen in that light, fiduciary duty must respect proportionality between the state and Indigenous peoples. And we already talked about what this duty is. The duty of fiduciary duty is to take care of those who you owe a duty to, right? But again, proportionality means that yes, you have to take care of them, but not to the exclusion of the greater good, right? When a court looks to infringements, it looks at the severity of the infringement. It's on a sliding scale to a great degree, right? States must recognize that Aboriginal rights have priority over non-Indigenous persons. It's their inherent land, right? The state must always first take measures for conservation of a resource. They must satisfy that the sustenance needs of the Indigenous peoples, whether they're First Nations or Métis, it could be non-status Indians, are looked after in the territory in which the infringement takes place, right? And then only thereafter can an infringement be looked at for the benefit of non-Indigenous persons, right? The Supreme Court of Canada in the Haida Nation case, this is the one in British Columbia, in 2002, also said that the state must implement a duty to consult and accommodate at any stage contemplating an infringement and not thereafter. So this is really important. This is in the last 20 years. And here's what this basically means. And this changes the whole context of how infringements take place. So the purpose of this decision was this, that, a government granting a license to a timber company or a mining company or a company that's going to build a hydroelectric dam or any other kinds of infringement before they are even given a license for that purpose. The government has to go to the First Nation, Métis community, whoever it's going to be. They have to go to them firstly and say, here is what we're planning to do. And not only that, here is how we plan to accommodate your interests as we go forward. The duty to consult and accommodate. All right. If that doesn't happen, if the Indigenous people see that they're not properly being advised what's going on and not properly given the opportunity to participate in the process, then what they almost always do is bring an application for what's called an injunction. Anybody know offhand what an injunction is? It's a court proceeding. If you're seeking an injunction, what are you seeking to do? Anybody? Elizabeth?
You'd be seeking to like stop the actions of what they're doing.
Yes, that's exactly what you're doing, right? An injunction is seeking to stop something from happening. So it's a court order doing that, right? You also have what are called interlocutory injunctions, which are temporary injunctions that are put in place to stop an activity until you actually get to trial to see whether or not you get a permanent injunction, right? This is really important because, if the only recourse was to get a permanent injunction at the end of a trial, then, somebody who was, on Indigenous lands, doing what they're doing, mining, cutting timber, whatever it would be, it takes years to get to trial. So, they would keep doing that, for 1, 2, 3 years, however long it took to get a trial until a permanent injunction is issued. But if the Indigenous group can get an interlocutory injunction, an interim injunction at the beginning of the activity, then that will stop the activity from doing any damage until it's finally adjudicated 2, 3 years later. Right? Injunctions, however, are also issued from the converse side of the coin, from those who legitimately are doing something, and Indigenous parties blockade them from doing anything further. So, sometimes somebody actually has got a license to do what they're supposed to be doing, and it's been approved by all levels of government and courts for that matter. But, a Indigenous group, whether it's a First Nation or what have you, decide that they still don't want it to go forward, and they set up blockades. Right? And we've seen there's lots and lots of blockades. We talked about this last week, and I think, and one of the groups doing the group presentations at the end of the semester are doing this. We're going to talk about, for instance, the Mohawk blockade in around Kingston, Ontario, which was in sympathy for the Wet'suwet'en hereditary chiefs trying to stop the pipeline in Alberta last year from being erected. So courts can issue injunctions to stop those people who are trying to develop resources, and they can also stop Indigenous groups from blockading the development of those resources. So it works both ways. All right. Interlocutory injunctions are purely discretionary, so clearly it's up to the court to decide. And here's what the court looks to when it's granting one. Is there a serious question to be tried? If it deals with Indigenous right being infringed, it's almost always serious. 2, will there be irreparable harm caused that can't be compensated with damages? Right. So what, for instance, what the Indigenous group has to prove to the court is, if you allow this company to clear cut, hundreds of hectares of timber, right? Then we've lost those woods forever. No amount of money is going to compensate us for the loss of those woods. Not unlike what we saw in the video. How can you put a price on souls? No amount of money is going to restore our souls for the lost land and use of those lands that we treasure, right? So that's irreparable harm. And what is the balance of convenience between the parties and waiting for trial, right? Is it going to cost the resource company billions of dollars to wait for trial versus the Indigenous group, trying to protect the territory in the meantime? So it's a balancing act that the court looks at, right? So courts are sensitive to disruption of economic activities, the harm to considerable investments by these kind of companies, the harm to local economies, right? So it's not always a slam dunk in getting an interlocutory injunction just because you want to stop development. However, courts almost always now rule against companies who are there with a license from the state or the crown that put their finances at risk, who don't engage in that duty to consult and accommodate we just talked about. Because that's clearly now for the last 19 years established as a constitutional requirement that if you are going to try to infringe upon Indigenous rights, you have the duty to consult and accommodate beforehand, right? To get around that, and this is what's developed in the last 20 years, and they're incredibly important. I talk a lot about this in the class on treaties that I teach. What have developed are what are called IBAs, impact and benefit agreements, right? And they're an end around the state's duty to consult and accommodate. And what they are essentially this, is that a company who wants to develop a resource, and that's almost what we're always talking about, again, cutting timber, hydroelectric dams, mining, anybody who wants to do that on traditional hereditary or traditional Aboriginal territory, what they do is they negotiate these impact benefit agreements with the Indigenous groups affected. And in doing that, and there's all kinds of things that are included in these agreements that are beneficial to both parties. So, but both parties have to come in agreement on them. When they do that, that satisfies the constitutional obligation to consult and accommodate. These agreements can provide for compensation for the Indigenous peoples. They can include hiring and training, for working on the site, right? So there's almost a first obligation to hire the local members of the First Nation or whatever it's going to be to actually work on the site. They will give contracts to Indigenous contractors. Some of these guys and women, they have large, machinery, large trucks and dozers, what have you. So there's a first right to hire them to do the kind of construction work that's necessary, basically. So again, these IBAs are seen to satisfy the Section 35 obligation to the duty to consult and accommodate, the Haida Nation test. All right, and the state being the Crown now increasingly requires virtually every company looking to do resource extraction to enter into one of these IBAs. Okay. So that's it for that particular part of the lecture. So we're going to move now to talk about modern treaties. All right, guys. Okay, so this is carrying on from last day. So last day we talked about, at the end of the class, we had a lecture on specific treaties, specific land treaties, and those and the specific claim process, which was essentially a process put in place by the federal government to assist with the negotiation and or the litigation of claims for breaches of existing treaties, right? Existing treaties being all the treaties that were put in place fundamentally since 1850 from Robinson Huron going forward. Some treaties, in the 1800s before that are also part of this that equation. Together with up to including 1975 with the James Bay Cree Treaty, which was the beginning of the modern era for treaties. So all those treaties that have been entered into that for the most part, the Indigenous peoples see that there's been a breach of obligations under the treaty. It could be financial, it could be resource, it could be educational. Any one of those terms of the treaties that have been breached can now be the subject of a specific claim. However, now we're talking about what are called comprehensive land claims or modern treaties. And again, remember, this has only been since 1975, so the last 45, 46 years has been the era of modern treaties. And the federal government has clearly seen that the honor of the Crown is at stake in implementing modern treaty obligations. They've taken it very seriously. And that's really important, obviously, because they've focused on trying to rectify all of the mistakes they made in all of what we now know as historical treaties up to 1975. So the honor of the Crown requires that all departments of the Crown, its agencies, and anybody working for the Crown, federal Crown, deal with honor, integrity, and fairness with anything they do having to deal with Indigenous peoples. All right, and those are very broad and general terms and not necessarily always lived up to, but they're certainly there as guidance. Comprehensive land claim agreements, which are the essence of modern treaties, are implemented by way of legislation, giving the treaties the force of law. So now, instead of, for instance, the Robinson Huron Treaty was never put into a statute, it is just simply a treaty by way of a contract between two parties. comprehensive land claim agreements embodied in modern treaties are likewise contracts between parties, but they're now also embedded into legislation that the federal government passes. So they have the force of law. They are statutory law. They're not constitutionalized, right? As well, they're constitutionalized in that they're endorsed by Section 35, but they're not a constitutional document per se. All right, but they are recognized and affirmed, right, for the purposes of fulfilling the obligations under Section 35. Okay. Again, the first negotiated modern treaty was the James Bay Northern Quebec Agreement with the Cree and the Inuit in the James Bay. And although that treaty was not mandated by the federal government, and we know that the provincial government went into and did it, its content has been provided ever since as a modern treaty. It's really interesting to note this, and this is really important. The treaty was entered into between the Cree and the Inuit and a provincial government. Right? It wasn't entered into with the federal government, which is contrary to the Royal Proclamation of 1763. It's contrary to the Indian Act, right? And it still is contrary to Canadian law, right? However, it's still used as the template for modern treaties. The reason I say this is that it can still be opened up and attacked by either party, the Cree and the Inuit, or the provincial government, on the basis that it is not properly constituted as a modern treaty. I just say that, but nobody, and I say this without hesitation, nobody, including any level of government, would ever want to open this thing up again. Okay, they just do not want to go back there and reopen up the treaty, which would obviously open up the compensation issues that may well be of more benefit to the Indigenous parties to the treaty than was originally negotiated 45 years ago. The treaty itself came from litigation over the James Bay project. So as I said this before, Quebec went in there to build this hydroelectric dam without consulting the Cree and the Inuit, and so they sued the government for that purpose. Right? Initially, negotiations broke down between the Cree and the Inuit, but it was being litigated like crazy. Right? The litigation was, incredibly, intense and comprehensive. And so, basically, the Cree, was suing the Quebec government for failure to consult and accommodate, basically. And after a 6-month hearing before the Quebec Superior Court, right, which is the trial division of the Superior Court in Quebec, the court found that the Cree and Inuit peoples, in fact, they had Aboriginal rights over the territory where the Quebec government was actually constructing the dam since time immemorial. Obviously, they had to call their historians to prove that, and they did. All right, and both parties, after that 6-month trial, realized that the costs, of litigating this issue, would take forever, would chew up tremendous amounts of resources, and instead they decided that they had to come to an agreement rather than to continue with the litigation, and they did that. Right. The next significant comprehensive land claim modern treaty after James Bay was the Nunavut Land Claims Agreement, which is really seen as a robust treaty that has terms for self-governance and land tenure rights, as in, what this did is this created the territory of Nunavut. So this is before your time. Nunavut's been around longer than almost all of you, I'm sure, but up until 1990s, Canada only had 2 territories, Northwest Territories and the Yukon Territory. And what this agreement did is it split the Northwest Territory into Nunavut and the remainder being Northwest Territory. Nunavut is now the largest territory and the most populated. It's also the largest comprehensive land claim agreement in Canada. And it took place in 1999, creating the 3rd Canadian Territory, basically. And what it did is it gave the peoples of Nunavut fee simple title to the land. I'm not going to ask you what that is, but it's an English property term, simply meaning that in this case, it's no longer the Crown owning the land, it's the people of Nunavut owning the land, right? So it's not the usufructory usage that we talked about in the last class. It's not a right simply to possess land, it's actual ownership. They also turned over $1.17 billion to be paid over 14 years. And you think about billions of dollars, nowadays you don't think about it as if any really a big deal, especially in the last year with COVID, because the federal government has spent, I don't know how many billions of dollars trying to keep the country together with CERB and all kinds of programs. It's because the economy has been devastated by the pandemic. So 1.7 billion doesn't 17 billion doesn't sound like a lot, but I guarantee you, over 20 years ago, the concept of $1 billion was an enormous concept, much more so than it is nowadays. But importantly, of course, what this agreement did is it created a new government, a new territory, and a new government. All right. Now, to talk about the steps in a comprehensive land claim process, again, this is to create a modern treaty. It starts when Indigenous peoples they submit a claim along with supporting materials asserting their rights to lands. Okay, so remember, this is only going to take place in those parts of Canada that already do not have treaties on them. So isn't going to take place in the areas of the Robinson, Huron, Superior treaties, or any of the 11 numbered treaties that we talked about previously, which go essentially from Ontario to to Alberta. So there are some parts of Ontario, northern parts of Ontario that weren't part of the numbered treaties that are subject to modern treaties. Quebec is where modern treaties are negotiated, as in, for instance, James Bay, as in the treaty with the Cree people that we saw in the video, in the film, as in almost all of British Columbia and parts of the Maritimes, right? So there's still large chunks of Canada that are subject to modern treaties and not the historic treaties that we talked about. And what happens is that you'll have Indigenous peoples, we'll say in British Columbia, who want to have a treaty put in place over their historical lands, traditional lands. They want to have a treaty put in place because they want to own it, and that's what these treaties now do. They want to own it outright. They want funds from the federal government for the purposes of creating the treaty, and they want everything else that goes along with modern treaties that gives them, potentially self-governance over those lands. Self-governance being incredibly important. All right, as in they run their own show. Essentially, they run the governance within the treaty lands, so they're no longer subject to the Indian Act. That Indian Act is out of the equation. There's no longer an Indian agent that they have to report to. That kind of thing. All right. So they basically, the federal government will accept the claim, right? So Indigenous group makes the claim to say we now want a comprehensive land claim here. If the Indigenous community can successfully confirm that they've had these lands as their traditional territory since time immemorial, which for the Supreme Court of Canada purposes is the time of British contact or French contact, that they've had an organized society on those lands since contact, basically, and that whatever Indigenous group is making the claim for this new treaty, that they've basically had that an organized society over those lands to the exclusion of other organized societies, primarily being other organized Indigenous societies. All right. The community must have traditionally occupied and used the territory to a sufficient extent so that it was an established fact at the time European sovereignty was asserted, right? So it had to be, right, a mature, think about this, a nation to nation, a mature culture and society at the time the Europeans showed up. Some current use, this is current, as in today, some current use and occupancy of those lands for traditional purposes must still be carried on. So we're talking about British Columbia, we're talking about maybe lands adjacent to the Pacific Ocean, right? So that, fishing, in the ocean for salmon in British Columbia, not only existed at the time that now it would have been the British, not the French, British Columbia, that the British showed up, and that it still continues, that there still is salmon fishing. That's required. The continuity is important, right? And lastly, the government requires that this title and this organized society over these lands has not been extinguished, right? We just talked a few minutes ago about what it takes to extinguish an Aboriginal title, all right? Or it hasn't been dealt with in another treaty, right? So you can't have a new modern treaty on lands that are already subject to for the most part, an historic treaty, right? So you can't be an Indigenous people who perhaps you want to get a better deal for those treaty lands and you want to negotiate a new treaty for one that is maybe 200 years old. That can't happen. So once the federal government has accepted that the claim should go forward, then it will then contact whatever province is there in the territory where the claim is being made, and the province, whether it's British Columbia, Quebec, a part of Ontario, maybe the Maritimes, whatever, Nova Scotia, New Brunswick, whatever it is, they have to sign on to this process as well. It is really a comprehensive land claim dealing with all levels of government. It's important to note that while the government will negotiate any Indigenous community with an acceptable claim, in practice, these negotiations have only taken place with First Nations and Inuit communities. Right? There has not been, to this point, a successful comprehensive land claim agreement put in place yet for Métis. Okay, so keep that in mind. Now this is the only video I'm showing you tonight. This is a talk on modern treaties and the law, right? So it's important to pay attention to this because it really does set out some substance for the purposes of comprehensive land claims.
It's a fairly high density gym zone up here. That's purely coincidental. It is, I suppose, obvious that there is no area of law in which the interplay and interaction between law and politics is more apparent than generally in the field of constitutional law. And if that's true, generally, it is equally true that there's no area of constitutional law in which the interplay and interaction between law and politics is more apparent than in the field of law dealing with the relationships between the Crown and Indigenous peoples. And without wanting to belabor this too much, if that's true, there's no area of constitutional law dealing with the relationship between the Crown and Indigenous peoples in which the interplay and interaction between law and politics is more apparent than the field of law that informs, leads to, and governs the entering into and implementation of modern treaties. Of course, the relationship between the Crown and Indigenous peoples is, like all relationships, inherently and necessarily political. And of course, the negotiation, settlement, ratification, and implementation of modern treaties is necessarily political. But the politics is inextricably related to, informed by, shaped and given effect by the legal rules and principles that govern the relationship between the Crown and Indigenous peoples that are enforced by the courts. They give the background, they give the context, they give the ground rules to the ongoing task of implementation of modern treaties. In the time available this morning, I'd like to take the opportunity to identify and say a few words about the state of the law coming out of the courts that is specifically concerned with modern treaties. And before I do that, it's worth emphasizing that, of course, all of the main legal principles applicable to the Crown-Indigenous relationship that apply generally, of course, apply in the context of modern treaties as well. It's also worth emphasizing that 14 years ago, when the coalition was formed, there was not yet, there didn't yet exist a body of law that was dealing specifically with the interpretation, nature, and effect of modern treaties. There is now an emerging body of law that is setting forth what modern treaties are and how they fit into the Canadian legal system. That's a good thing in a way. It's unfortunate in a way. I say it's unfortunate only because you only end up going to court when there have been disputes. So the fact that there's an emerging body of law is the result of the fact that over the course of those 14 years, people were obliged to go to court to settle their disputes. You know, my first couple of months of law school, somebody passed around a cartoon. I'm sorry, this has nothing to do with anything, but just disputes reminded me of it. And the cartoon was called The Dispute. And there was a picture of a cow, and on one end of the cow, there was a person pulling the cow by the head, and on the other end, the person was pulling the cow by the tail, and in the middle was a lawyer who was milking the cow. I don't want to say that influenced my entire approach to law ever since, but it's worth noting. Courts only get involved and pronounce on the law when there is a dispute. That's right, but that has political effects. So as Jim just mentioned, of course, the Calder case in 1973 was the result of a dispute as to whether or not Aboriginal title continued to exist, and the Nisga'a took the Attorney General of British Columbia to court, resulted in the Calder decision. That's a legal development, but the political consequence was the establishment by the federal government of the so-called comprehensive land claims policy that led to all the modern treaties. Similar interaction happened, of course, with the James Bay Northern Quebec Agreement, which was, in fact, an out-of-court settlement of a lawsuit brought by the James Bay Cree against the hydroelectric projects. There's this interaction, a mutual informing of law and politics that sets out and defines what we're all doing here today. Now, I mentioned that since the 2000s, there's now an emerging body of law. I'm just going to go through a bunch of cases and read a few things that, to the best of my ability, summarize the state of the jurisprudence as to the nature of modern treaties. The first case I'll refer to is a decision of the Supreme Court of Canada called Quebec versus Moses, 2010. For those of you who care, 2010 SCC 17. It was a decision made in May of 2010, and it was a dispute that really involved the relationship between the federal and provincial environmental legislation in light of the James Bay and Northern Quebec Agreement. And during the course of deciding whether or not federal jurisdiction had been limited by the treaty, the Supreme Court of Canada pronounced for what I believe to be the first time on the nature of modern treaties. Writing for the majority, Justice Binney observed, and I quote, he said, in Regina versus Badger, Corey pointed out that Aboriginal treaties are analogous to contracts, albeit of a very solemn and special public nature. At issue in that case was an 1899 treaty. The contract analogy is even more apt in relation to a modern comprehensive treaty, whose terms, unlike in 1899, are not constituted by an exchange of verbal promises reduced to writing in a language many of the Aboriginal signatories didn't understand. The text of modern treaties is meticulously negotiated by well-resourced parties. The importance and complexity of the actual text is one of the features that distinguishes the historic treaties, he meant historical, made with Aboriginal people from the modern comprehensive agreement or treaty of which the James Bay Treaty was the pioneer. We should therefore pay close attention to its terms. Now let me pause. Very important concept going on in that passage that I just read. It's recognizing one of the three facets, or aspects, or faces, or ways of looking at modern treaties. Modern treaties are contracts, entered into by, as the court said, well-resourced parties who meticulously negotiate its terms, and they have the force of contract. I should pause and say that modern treaties are also statutes. They're statutorily ratified, they're given the force of law, they're made binding on the world, they're not simply contracts between the parties, they're part of the law of the land. That's the second aspect. And the third aspect is that they are constitutional instruments that inform and govern the country at the constitutional level as well. And that point is picked up by the minority in Moses, who dissented about the particular terms governing environmental assessments, but the observations they made about the nature of modern treaties were not any different than what was said by the majority. And Justices Lebel and Deschamps said in part, the agreement is both an intergovernmental agreement and an Aboriginal rights agreement. It has those two aspects. It is binding upon and creates rights and obligations for the federal and provincial governments and the First Nations. It may be viewed as a model for the many modern land treaties that have been signed since the 1982 constitutional amendments, which include the protection of what are now referred to as modern treaty rights under Section 35(3). They continue, the agreement is far more comprehensive in scope than either the treaties of peace and friendship, Jim talked about, or the numbered treaties considered by this court in a number of cases in which the analytical framework for interpreting the historical treaties between certain First Nations, Canada and Great Britain was developed. They then quote Professor Sébastien Gramont, who said that modern treaties tend to address far more than just the ceding of territory. Professor Gramont said in the passage approved, modern treaties therefore cover a much wider range of subjects than the territorial treaties of the 19th century. In modern treaties, the Crown and Aboriginal peoples have tried to specifically define the rights and obligations in many areas, such as land use, hunting, fishing, sharing of royalties for the use of natural resources, environmental assessment, economic development, preferential hiring, awarding of contracts, adaptation of public services. The most recent agreements also include provisions on self-government, dispute arbitration, and coordination with the claims of neighboring Aboriginal peoples. The minority says this agreement, referring to the JBNQA, fits this description well. It establishes a comprehensive legal framework setting out the parties' respective responsibilities where services and rights to land are concerned and organizing their relationships for the future. It's one of the ways in which modern treaties are unique. They're different from the historical treaties because of their breadth, but they're also quite different from much narrower agreements, such as exist, for example, with groups that have a self-government agreement, but not a modern treaty. That deals with an important facet of the relationship, but what the court is stressing about modern treaties, comprehensive land claims agreements, is their breadth. They seek to inform and specify the nature of the relationship in myriad different ways. The next case I want to tell you a little bit about is called Beckman versus Little Salmon Carmacks First Nation. Came out of the Yukon, 2010, Supreme Court of Canada 53. And the issue in that case was whether or not the Yukon final agreements exhaustively set out the Crown's duty to consult if the Crown was going to take actions that would adversely affect, that did adversely affect, the treaty rights. In other words, is the modern treaty a complete code that excludes other fundamental constitutional principles and only includes the things that are specifically and expressly referred to in the agreement? That's what the Crown argued. And ultimately, people are no doubt aware, the Supreme Court of Canada said that there is an ongoing common law duty to consult with Indigenous people if the Crown proposes actions that may adversely affect a treaty right. And it's not exhaustively set out within the four corners of the agreement, that there's a common law constitutional framework within which the treaty was negotiated, which continues to apply. What the court's observations along the way, and this is again Justice Binney, said, and I quote, unlike their historical counterparts, the modern comprehensive treaty is the product of lengthy negotiations between well-resourced and sophisticated parties. The reconciliation of Aboriginal and non-Aboriginal Canadians in a mutually respectful long-term relationship is the grand purpose of Section 35 of the Constitution Act. The modern treaties, including these at issue here, attempt to further the objective of reconciliation, not only by addressing grievances over land, but by creating the legal basis to foster a positive long-term relationship between Aboriginal and non-Aboriginal communities. And then he speaks directly to the officialdoms that implement treaties. And Justice Binney wrote, thoughtful administration of the treaty will help manage, even if it fails to eliminate, some of the misunderstandings and grievances that have characterized the past. Still, as the facts of this case show, the treaty will not accomplish its purpose if it is interpreted by officials in an ungenerous manner or as if it were an everyday commercial contract. The treaty is as much about building relationships as it is about the settlement of ancient grievances. The future is more important than the past. A canoeist who hopes to make progress faces forwards, not backwards. I want you to know we all appreciated Justice Binney's helpful nautical tip. But the important part of that paragraph is referring to, yes, it's a contract, but it's a contract that has to be interpreted in a way that achieves its purposes. It can't be interpreted in an ungenerous way or with mere attention to the strict, literal, technical interpretation of its terms. Justice Binney continues, the increased detail and sophistication of modern treaties represents a quantum leap beyond the pre-Confederation historical treaties. The historical treaties were typically expressed in lofty terms of high generality and were often ambiguous. The courts were obliged to resort to general principles such as the honor of the crown to fill the gaps and achieve a fair outcome. Modern comprehensive land claims agreements, on the other hand, starting perhaps with the James Bay and Northern Quebec Agreement, while still to be interpreted and applied in a manner that upholds the honor of the crown, were nevertheless intended to create some precision around property and governance rights and obligations. Instead of ad hoc remedies to smooth the way to reconciliation, the modern treaties are designed to place Aboriginal and non-Aboriginal relations in the mainstream legal system with the advantages of continuity, transparency, and predictability. It is up to the parties when treaty issues arise to act diligently to advance their respective interests. So the concept of acting diligently when issues arise is fundamental to the continuity, transparency, and predictability. Justice Binney continues, good government requires that decisions be taken in a timely way. That's a useful hope. To the extent that territorial government argues that the Yukon treaties represent a new departure, I think it's correct. However, as the trial judge Vale J. aptly remarked, the new departure represents but a step, albeit a very important step, in the long journey of reconciliation. Treaties don't finish reconciliation. Reconciliation isn't something to be achieved and now it's over. We have reconciled. Reconciliation is a process, a continuing journey together that's supposed to be done within the relationship as defined by the modern treaties, but being renewed and built upon day after day after day in a way that reflects the parties' diligence and intention to achieve the objectives. The next cases that I want to talk about briefly had to do with one of the big changes that happened in modern treaties that took place with the Nisga'a Treaty, in fact. Nisga'a Treaty was the first modern treaty to actually include within its terms all of the detailed rules governing Nisga'a government or self-government. All of the modern treaties since the Nisga'a Agreement have done so as well, but the Nisga'a Agreement was the first one to do that and to give them constitutional protection. And many people may recall the outcry, nay, dare I say, the hysteria in certain quarters of the land at the idea that Indigenous people might actually have constitutionally protected self-government. And people might recall that the Nisga'a Treaty was taken to court by the then leader of the opposition in British Columbia, Gordon Campbell, who went to trial and did not succeed, of course, and then he became premier, and then he discontinued the action. But some others picked it up. Some Nisga'a individuals supported by lawyers, who wanted to pursue the question of whether or not the self-government provisions of the Nisga'a Treaty were unconstitutional. And in arguing the case, one of the things that struck me was ironic, is they seemed to be saying, we can make a promise to you that you can govern yourselves, but if we can't break that promise, then it's unconstitutional. We will only make you this promise on the basis that we can break our promise. That's okay. Right? But as soon as you say, no, the Crown can't break its promise, no, that's unconstitutional. Very strange view of the universe. Anyways, rejected. And it was rejected at trial, and then the matter proceeded to the British Columbia Court of Appeal, who, of course, upheld the Niska Treaty. And the application for leave to appeal to the Supreme Court of Canada was denied, so that leaves the Court of Appeal decision in place. It was in February of 2013. And the British Columbia Court of Appeal, in responding to this idea that somehow giving constitutional protection to the self-government terms of modern treaty is unconstitutional, replied by saying, I quote, "The treaty is a complex, detailed, and comprehensive agreement addressing all aspects of the continuing relationship between the Nisga'a Nation, Canada, and British Columbia, as well as the powers of Niska government to make laws in relation to matters vital to the Niska, including the preservation of Niska culture, language, and education, lands and resources, and other matters integral to the continuing viability of the Niska Nation as an Aboriginal people within Canada. Importantly, for the purposes of this appeal, the treaty expressly recognizes that the Nisga'a Nation has the right of self-government and the authority to make laws, as set out in the agreement. After discussing all of the arguments back and forth, the Court of Appeal concluded, I am unable to conclude that the combination of the treaty and settlement legislation breaches any constitutional prohibitions. The treaty has been carefully crafted to respect constitutional principle and to fit into the wider constitutional fabric of Canada. It is what it purports to be, an honorable attempt to resolve important but disputed claims, to achieve reconciliation, and to lay the foundation for a productive and harmonious future relationship between the Nisga'a Nation and the non-Aboriginal population of Canada. The themes continue to be repeated. Reconciliation is not a final product. The treaty sets the basis for the ongoing relationship. But as the Court of Appeal said of the Niska Treaty, could equally be said about all of the other modern treaties. They are complex, detailed, meticulously negotiated, comprehensive agreements that fit totally within the constitutional fabric and nature of this country. The courts have repeatedly said that. The courts like the idea of modern treaties to set forth the basis of the relationship, because then they don't have to, and it's better for everyone. One of the cases that came along because of a dispute when things weren't going that well was an action that was brought by NTI in 2006 as a result of ongoing breaches of the Nunavut Agreement by the federal Crown. It was a very complicated lawsuit. It went on for a long time. It was ultimately settled, which is always a good thing. It's always better to settle cases than not to. But a very small part, but a significant part of the NTI lawsuit had to do with one of the enumerated 14 or 15 breaches, I don't recall now. It had to do with the requirement on the part of the Crown to establish and conduct general monitoring, environmental monitoring as part of the planning process. And there was a particular provision of the Nunavut Agreement requiring that to take place, and the Crown just didn't do it, just hadn't done it. And there was a lot of reasons that were given and so on, but there was no question about it. The Crown admitted on discovery, no, we didn't do that. And after the action got going, then a few years in, the Crown and NTI sat down, and now it's going to start, and it was budgeted for, and that gave an estimation of the cost of actually carrying out the general monitoring. So it was kind of an unusual situation because there was both an admission of the plain fact of non-compliance and the possibility to do a calculation as to what the Crown had in fact saved by failing to keep its promise. The Crown had, in effect, pocketed the money that it would have spent had it kept its promise. And it was possible to calculate how much that was. So NTI brought on a motion for summary judgment on just that small part of the claim. And why I want to talk about that for a minute is a couple of reasons, but one is because it focused on the contractual nature of the treaty. Remember, I said treaties have these three faces: their contracts, their statutes, and their constitutional instruments. And often in litigation, the focus has been upon their statutory force or the constitutional force. The NTI lawsuit focuses on the contractual nature of the dispute. The thing is that in the Canadian legal system, the common law system in England, the United States, the normal remedy for breach of a contract is what they call expectation damages. In other words, if a plaintiff is able to convince the court that the defendant has breached the treaty, then the court makes an order to put the plaintiff in the position that they would have been in, so much as money can do, as if the contract had not been breached. It's called expectation damages. But in this case, it was very difficult to do that. Well, how much money is the failure over a period of time to conduct environmental monitoring, general monitoring, how much money would compensate us for that? And the argument that was put forward is you can't calculate that. But it would be unfair if all the Inuit got was nominal damages. Here's your dollar. We can't calculate it. Because we knew from the budgetary cost that over the period of that many years, the Crown had saved roughly $15 million. Put it in its pocket. So what we argued was that the special circumstances required a principle of what's called in law, it's a wonderful term, disgorgement to apply. It's good, isn't it? Disgorge. The Crown has to disgorge itself of the money that it received. Disgorgement is often a remedy for breach of fiduciary duty. I don't want to get into it in much detail, but it's very rare for breach of contract. In fact, disgorgement hasn't been ordered for breach of contract in Canada until this case. And when all of this was laid out and presented to the Nunavut court, the trial judge, or the Chamber's judge on the summary motion, said the following: the Crown was indifferent to its obligations over many years and was only prodded into action by this lawsuit. Even then, it took almost 4 years before the money started to flow. Canada's breach was not an efficient breach because the Inuit are worse off while the Crown is better off. I'm satisfied, said the judge, that Canada's failure to implement an important article of the land claim for over 15 years undermined the confidence of Aboriginal people, and the Inuit in particular, in the important public value behind Canadian land claims agreements. That value is to reconcile Aboriginal people and the Crown. It would be manifestly unjust to allow the Crown to benefit from its failure to fulfill its obligations. It is also important that to ensure that the Crown properly respects and fulfills its obligations under land claims agreements, including obligations to provide benefits that are not capable of being quantified in financial terms. NTI's motion for summary judgment is granted. I award NTI damages in the amount of $14,817,500. The Crown appealed. And it went to the Nunavut Court of Appeal, which is the Alberta Court of Appeal, more or less. And when it went to the appeal, ultimately, the Court of Appeal argued that it was not appropriate on summary judgment without a trial to settle on the amount of $14,817,500. That amount was derived from what the Crown government did budget when it started implementing the General Monitoring Plan, but the court said it's not clear that that's the number that should be used. There should be a trial on the quantum. But on the principle of whether or not the Crown can be forced to disgorge any money that it saves by virtue of its own breach of modern treaties, the Court of Appeal upheld the trial judge. The Court of Appeal said this: the appellant received, that's the Crown, valuable consideration for the covenant, the promise, to establish a system of statistical monitoring. If it could simply refuse to perform that covenant and argue that it need not pay any damages because none could readily be established, it would potentially deprive the Inuit of many of the intended benefits of the land claims agreement. In the context of a land claims treaty, insulating the contracting government from any consequences of a breach of a covenant like this is legally unacceptable. As a result, the case management judge was correct in concluding that the respondent is not limited to a claim for nominal damages. some appropriate measure of damages must be found. The savings achieved by the Crown in not performing are different in character from the profits recovered in this case, but similar to those recovered in that case.
All right, guys. All right, that was really, really well done. So, and almost everybody stuck with it. So, thank you very much for doing that. That's a really good explanation on, the why and how modern treaties came into play, how important they are, the various factors of them, and how they're dealt with. And what this does, of course, is it, obviously gives you also a picture of, how difficult sometimes they can be to negotiate and to enforce. All right, so the rest of the lecture is going to be basically on the intricacies of modern treaties that I can tell you how they're arrived at and what have you. All right, so let's go through that and then we're done. All right, so once the parties agree that they're going to negotiate a modern treaty, then they enter into what's called a memorandum of understanding, an MOU. And what that does is that signifies that the parties are committed to actually negotiate a modern treaty. At the first stage of negotiations, a framework development is put into place. And that's really, really important because what that sets out for the purposes of the entire negotiation, what is going to be dealt with. And importantly, deadlines for reaching various stages of the agreements in principle, right? The negotiations, as you can imagine, are often complex. So coming up with the framework agreement tends to be a very lengthy stage of the negotiation because that is the stage where all the elements are at least set out in a preliminary kind of fashion. Once finalized, the agreement in principle contains the essential components of the final agreement. So as you can imagine, the real crux of a negotiation takes place at the very beginning, where what is intended to be included is set out for the purposes of future negotiations. All parties have to agree to it, right, to sign and ratify the agreement. That just makes sense. And then eventually what happens when the agreement comes into place, legislation will be passed to give effect to the final agreement, which again gives it the status of a federal statute, which means, and as the gentleman said in the video, it's just not now a agreement between the parties themselves, but it's the law of Canada, right? So all parties have to respect it and abide by it if they ever come into contact with it. After that is done and as part of the process, a final agreement implementation plan is also negotiated, right? And that's part of the final negotiations. And implementation is the operative word there. Basically, it's appended, or it's an appendix to the agreement itself, right? And what it basically does is sets out who will be responsible for implementing all the things that have to take place that have been agreed to. Annual reports are also issued after the agreement has been signed, which gives an annual updating essentially of the activities of a party in implementing all of its provisions. 5-year reviews are also done, and that's a detailed 5-year analysis of the agreement, basically saying here is what was intended to be put into place, in the 5 years going forward, and here is what essentially has been put in place. Here are the parties that had the responsibility to do this, and here's what the parties have actually done in doing that. All right, so that kind of makes sense, hopefully. And what it also does is it gives the parties to the agreement a template going forward as to, all right, you are responsible to do this, and you didn't do it. Here's how it has to be done in the future, right? For the purposes of facilitating this, the federal government, has put a lot of time and money into this. And this is all online. If you wanted to Google it, you could easily find this material. But what's put in place is what's called the Federal Framework for the Management of Modern Treaties, Implementation Management Framework, right? So again, it's online and is quite straightforward for the purposes of following it, right? The intent of doing that and making it such a public document is to clearly strengthen the management of modern treaty implementation, right? It helps, this is the framework and the implementation plan, it helps federal officials fulfill Canada's responsibilities in modern treaties. It ensures those responsibilities are coordinated, they're consistent and done in a timely manner. It does it by improving information sharing, obviously, identifying which parties have to do what and in what timeframes. It improves oversight of the obligations under the treaty. It clarifies accountabilities and responsibilities. facilitates efficient decision making, right? So these are all obviously very good things. Since the first concept created for a comprehensive land claim agreement in 1973, which was the commencement of the negotiation of the James Bay Northern Quebec Agreement, 24 modern treaties have been negotiated. So in 45 years, 24 agreements. So not quite one every 2 years. But it's covered in a tremendous amount of land mass, up to 40% of Canada's land mass in total. So that tells you how large some of these treaties have been, particularly since it's dealing with those parts of Canada that weren't already subject to historic treaties or historical treaties. Implementation plans for these agreements usually have between 100 and 200 obligations for each party. That's the federal government and the Indigenous party signing it, right? The federal government is responsible usually for most of those obligations, but there are still a lot that the Indigenous parties have to abide by. And the majority of those obligations are still ongoing. So it's not as if the Comprehensive Land Claim Agreement, incorporated by statute into a modern treaty, has these obligations that come to an end and nothing follows from that. Some obligations clearly do come to an end if they deal with things like construction of a particular project that's relative to resource extraction as part of the modern treaty. Then yeah, sure, that can come to an end. The construction phase can come to the end, but there's almost always ongoing responsibilities after the construction is done. For instance, the carrying on of whatever resource extraction business was developed, mining, timber, hydroelectric, whatever it's going to be. The agreements cover a wide range of subjects. Importantly, the title and management of the lands. Again, these agreements, I can't say this enough, these agreements deal with the transferring of fee simple, the English concept of ownership, of full ownership in the lands, basically. They'll deal with wildlife, aquatic resource management, parks and conservation, environmental reviews, and the gentleman in the video talked about that with respect to one of the treaties, monitoring of those reviews, land and wastewater management, mining, heritage resources, economic development, incredibly important, obviously, as part of the treaty, government contracting, taxation, capital transfers, public sector employment. All of these things are incredibly important and almost now form a part of every comprehensive land claim agreement leading to a modern treaty. What's also really, really important are dispute resolution mechanisms, right? And we talked about this with respect to specific claims last week. What happens when disputes arise between the parties and they need to be resolved, right? You don't want to have to litigate them all for the most part, right? And that's why, for instance, dealing with historical treaties, you have a specific claims tribunal. Again, most modern treaties provide for self-government, right, which is incredibly important. This is an operation of Section 35 of the Constitution. What they allow for are new Indigenous government structures, new jurisdictional and programming arrangements for things like health, education, social services, and infrastructure. It's incredibly important that what we're talking about here is transferring the responsibility for these things, health and education, transferring into the hands of the Indigenous peoples themselves, who now, can take care of their own people health-wise and educate their own young people, right? We're no longer relying upon, in the historical treaties, firstly, the establishment of on-site reserve schools, right, with teachers hired, white teachers hired for those purposes. Then, of course, morphing into residential schools, which we've already talked about, right? We're now light years beyond that. We're now talking about internal care and control over those kind of things. Incredibly important, obviously. It's recognized, of course, that again there are disagreements that arise as a function of the implementation of all these obligations. And so what we also have, again, online by the federal government, is a guide for the management of dispute resolution mechanisms in modern treaties, right? So it's put in place there to mirror, to a great degree, the specific claims tribunal for historical treaties, although it's a little more, it's certainly more comprehensively aimed at the issues that are now in modern treaties that aren't in historical treaties. The idea, of course, is to increase transparency and credibility of a settlement process for disputes, okay? The guide that's put in place describes the range of disputes there may well be, and a process for resolving them, all the way from consensual negotiation to adjudication, which usually means a tribunal or arbitration. Right? There's clearly little doubt that almost any resolution that is resolved by the parties themselves is the best way to resolve them. You don't necessarily always want to bring in lawyers and or third parties into these processes. But failing that, then you do and can move to the addition of neutral third parties for assistance, right? So, the government of Canada looks at that as a staged approach as to, how you go from a consensual negotiation to a litigious solution, right? So you have a staged approach. So the first one is A, informal discussions. B is assisted or facilitated negotiations, including mediation, and C, arbitration being litigation, essentially, right? The majority of the treaties include those processes as voluntary, so the parties, enter into them, the alternate dispute resolution processes on a voluntary nature, right, as an alternative to litigation, right? The stage one informal processes, basically the parties, they form committees or panels to discuss things amongst themselves. All right, so again, it's a voluntary, informal to a great degree situation where you're not hiring, third parties to become involved in the process. These parties are crucial in trying to resolve the disputes, basically. And here is where issues are raised and differences of opinion are identified and discussed. It's also a forum for the parties to bring their own experts to speak if they wish. So again, if it's a issue dealing with something to deal with resources, for instance, or some construction matter or what have you, then each party can bring in their own experts. This doesn't make it part of a litigious process. It's not. It's just a well-informed process. Stage two are the assisted negotiations. So this is where we're bringing in a neutral third party, which for the most part is going to be a mediator. Okay, so it's a mediator who comes in, who basically listens to both sides of the story, right? So they're a neutral third party. That third party, the mediator, can bring in their own technical experts or legal experts who can make suggestions. And again, this is all a informal, to some degree, voluntary process. Nobody has to accept what the mediator has to say. This is not a binding arbitration process. The experts that come in provide an objective viewpoint to the dispute. Doesn't matter which party they come in for. Failing that, so failing a negotiated agreement between the parties and failing a neutral third-party mediator coming into the process, then we have arbitration. All right, arbitration is stage three. This is when the first two processes have not resulted in a resolution. And most modern treaties have mechanisms in them to submit matters to arbitration. The treaties also set out the powers of the arbitrator and the processes to be followed, which is a standard process for all arbitrations. The most common form of arbitrations in Canada are labor arbitrations, where unions argue issues with employers over collective agreements, for the most part, binding collective agreements. So Algoma University, for instance, has two unions that it deals with. The employer deals with. It deals with a union for the staff. These are the people who work in the offices, work in the back offices, work do the janitorial work, those kind of things. That's the OSSTF, the Ontario Secondary School Teachers Federation Union. And then all the faculty belong to OPSU Local 685. It's the full-time faculty and the part-time faculty. I'm the president of that particular union. And so we negotiate collective agreements and resolve disputes when there's an alleged breach of those agreements between an employee, which would be a member of the faculty, and the university, the administration, right? Well, it's the same kind of thing here. Right? It's if you have a dispute that you can't resolve with negotiation or mediation, then it goes to arbitration, which means a third-party arbitrator is hired. In these cases, it's going to be somebody who knows how modern treaties are supposed to work, right? And it works very much like a court process where you have lawyers who present their case to the arbitrator. There's rules of evidence. People give testimony, and the arbitrator will make a decision, just like a judge makes a decision, and it's binding on the parties. So, that's an important consideration. All of these things are built into the modern treaty process. There are two instances where, in fact, Canada, as a party to a modern treaty, will not submit to arbitration when it deals with the implementation of terms of a modern treaty. The first deals with funding matters. Funding matters being the funding of the public purse, not funding as in we're going to pay you $2 billion for these lands. It's funding matters that deals with regular public sector funding. They won't negotiate that as a part of a modern treaty, and they won't put that to arbitration. And secondly, they won't negotiate what's called public law. So they won't consent to arbitration on matters of law or mixed law and fact that deal with general constitutional principles or contract law, tax law, or pure questions of law before an arbitrator, right? That's kind of technical, but it's the field of public law. They will not arbitrate that. They will insist that those issues, these kind of issues, go to a court of law in whatever jurisdiction the treaty relates to. So if it's in British Columbia, it'd be the Supreme Court of British Columbia. If it's Nunavut, it's Nunavut Superior Court, which is actually, again, the Alberta Superior Court. That's just the way it works out. Okay, guys, so that's it for modern treaties. So there we go. I can tell you that next week, we're going to be dealing with missing and murdered Indigenous women and girls. So Michelle, if you cry for all the other videos you've seen, I'll make sure I find a video that you'll cry for this one particularly. There's lots of very sad stuff out there about this particular topic, but that's what we're going to be doing for next week. But in the meantime, now we're going to go to the breakout sessions. So again, I'll put you into the breakout rooms for 12 minutes and bring you back to discuss the 5 questions that are on Moodle.